We all recognize that property can be foreclosed on for failure to pay a tax debt. What happens when the value of the foreclosure, though, is greater than the debt owed? A case out of Michigan recently appealed to the Sixth Circuit seeks redress for just such situations. 8 citizens of Oakland County, Michigan are suing the county for, among other things, taking property worth far more than the tax debt owed, then not reimbursing them the difference. Now, is this an illegal taking or a deprivation of property without due process? Or could it simply be a scheme to defraud both the homeowners and taxpayers of Oakland County? We'll discuss that next on the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello there, everyday Americans, and welcome to the Constitution Study, where we read and study the Constitution. We teach the rising generation to be free. I am so glad you could join me today. And as always, if you want to find out more, head to constitutionstudy.com. I'm putting together a tour for this summer. So if you'd like to know where I'm going, or even better, if you'd like to invite me to come speak to your event, to your group, or just to a coffee clutch, check it out. Head to constitutionstudy.com/tour for details on the tour, or you can find it through the main page. You can ask a question, you can sign up for the newsletter, you can find the videos, you can share the videos. All of that is there on the Constitution Study. Now, I'll talk a bit more about that at the end of the video, but for now, let's talk about these foreclosure issues. Something appears rotten in the city of Southfield in the county of Oakland in the state of Michigan. In the case of Tonawanda Hall et al. Versus Edward Meisner, Oakland County Treasurer et al., some truly disturbing facts have come to light. Before I get into the details of the case, a little background is required. Though not the issue before the court, I was shocked not only by the actions of several county officials, but by the fact that no one seems to be investigating apparent embezzlement by those officials. When the homeowners in this case failed to pay their property taxes on time, the court foreclosed. The homes were not sold at auction, but transferred through a series of transactions to a company managed by city officials, the Southfield Neighborhood Revitalization Company, LLC, for a payment of the tax debt plus $1 each. Now, while foreclosure for an unpaid debt is a terrible situation to be in, what the city of Southfield and Oakland County did next is unconscionable. None of the homeowners were paid for what was taken from them because a state statute purported to authorize cities to purchase for a public purpose tax foreclosed property by paying the county the accrued tax debt. The asserted public purpose, according to the resolution adopted by the City Council, was to revitalize and stabilize neighborhoods and rehabilitate and renovate these homes and then return them to productive use and purchase by individuals and families seeking housing opportunities within the city of Southfield. That's City Resolution 45-5. City Council members also said at another meeting that conveyance of the property from the county through the city to the company would attract residents with more income. Both the Fifth Amendment to the Constitution of the United States and Article 10, Section 2 of the Michigan Constitution state that private property may not be taken for public use without just compensation. This brings up a constitutional issue since these properties were not taken by the city for public use. Now, we can thank the Supreme Court in the case Kelo versus City of New London for that, where the court found that taking private property to sell to a private entity was public use because it would lead to public improvement, specifically revitalizing a blighted neighborhood. Now we have the City Council of Southfield, Michigan using the same logic to purchase these properties to increase their tax base. But the malfeasance doesn't stop there. With the City Council's authority, Mayor Kenson Sivers signed a contract with the Southfield Nonprofit Housing Corporation, which owns the company, the Southfield Revitalization Initiative, to execute this arrangement. The nonprofit and company are both controlled by city officials. Mayor Sivers is president of the nonprofit and signed the paperwork creating the company. City Manager Fred Zorn is a board member and vice president of the nonprofit and the manager and registered agent for the company. To say that the mayor and city manager of Southfield have a conflict of interest is an understatement. The mayor of Southfield, with the city council's permission, has contracted with a nonprofit that he controls to do business with a company that the nonprofit owns and is managed by the city manager. Now, if that were all, it certainly would be worth investigation. But how these entities deal with the foreclosures is truly criminal in my mind. Let's take a look at the example of Tawanda Hall. Tawanda Hall owned a home with her now deceased husband at 24650 Martha Washington Drive, Southfield, Michigan in 2010. On February 14, 2018, the county foreclosed and took title of the property to collect $22,642 in property taxes, interest, penalties, and fees. Without notice, on June 29, 2018, the county treasurer deeded the property to the city, which paid the tax debt with funds from the nonprofit. On October 23, 2018, the city gave the property to the company for $1. The company later sold the Hall's home for its fair market value of $308,000, $285,000 more than the Hall's own tax debt, and kept all the proceeds. There are questions as to whether the county followed Michigan law regarding the foreclosure, but that's not what I'm focusing on here today. Just 4 months after foreclosing on the property, the county treasurer deeded the property to the city, who paid the tax debt with money from Southfield Nonprofit Housing Corporation, which is run by the city mayor. Now, the city owns a piece of property worth $308,000 for the low cost of just $22,642 paid by someone else. In other words, the city received that property for free. The city then sells the property to Southfield Neighborhood Revitalization Initiative, LLC, a for-profit corporation, which is managed by the Southfield city manager for the low price of just $1. Ms. Hall is only one of 8 people seeking a redress for this type of grievance. In August 2020, these 8 homeowners filed this federal lawsuit against the parties involved in the confiscation of their properties: the county, city, public officials, the company, the nonprofit, and the managers of the company. At issue in this appeal, the homeowners allege that all the appellees took their private property without just compensation. The city, the county, and public officials imposed excessive fines. The county and its treasurer violated procedural due process, and the company, nonprofit, city, and its officials were liable to return the windfall received at the homeowner's expense under the doctrine of unjust enrichment. While there are several issues in this lawsuit, this appeal only focuses on a few. Did the county, city, et al. Take private property without just compensation? Did they impose excessive fines and violate due process? Well, let's take a look at these individually. Under the constitutions of the United States and Michigan, we read, "Nor shall private property be taken for public use without just compensation." Now, as I mentioned previously, this property was not taken for the public use. First, it was foreclosed on by the county for failure to pay taxes. Then it was transferred to the city in exchange for the tax debt. The alleged public purpose was to enlarge the tax base of the city, not for the property to be used by the public. That means this is not a takings clause issue. However, under Michigan common law, the Michigan Supreme Court has held that government effects an uncompensated taking or is liable for unjust enrichment when government takes more than it is owed during property tax collection. The practice of municipal governments gaining a windfall after foreclosing on property is nothing new. The question is it legal? Now, this would seem to revolve around the definition of a fine, to impose a pecuniary or financial punishment. In English, a fine is a punishment that is evaluated in monetary terms. The tax these people owed was not a fine, it was a tax. When they failed to pay their taxes on time, they accrued both interest and fines, or monetary punishment for their failure to make timely payment. The question is, when the county foreclosed, were they imposing a fine? Since the property that was forfeit was used to pay off both the debts and the fines, it could certainly be considered a fine, a monetary punishment. This is important because the 8th Amendment states, "Nor excessive fines be imposed." Is a $308,000 fine imposed on a $22,642 debt excessive? I would certainly say that a fine more than 13 times the debt is excessive. If you borrowed money from someone and they demanded you pay back 13 times more than you borrowed, we'd call that person a loan shark. So yes, this certainly seems to be a case of excessive fines. The 5th Amendment says, "Nor be deprived of life, liberty, or property without due process of law." We often hear it talked about, but what is due process of law? Well, from the Law Dictionary, law in its regular course of administration through courts of justice. Due process of law in each particular case means such an exercise of the powers of government of the government as the settled maxims of law permit and sanction, and under such safeguards for the protection of individual rights as those maxims prescribe for the class of case to which the one in question belongs. So the Law Dictionary provides two senses of due process that apply to this case. First, it's the administration of law through the courts. Second, it's the exercise of governmental powers under the safeguards for the protection of individual rights. Now, as it pertains to this case, was the property taken following the protection of the rights of the individual? I'd say the answer here is no. With this appeal, the appellants claim that the county did not provide them adequate notice that they were disposing of their property. Many complain that the county either violated the terms of their payment agreement or fraudulently advised them on how to respond to legal notices. That certainly would appear to violate due process. Furthermore, since the debt owed to the county was a fraction of the value of the property seized, due process and Michigan common law requires the government to keep only what it is owed. In Raffaelli, the Michigan Supreme Court held that where government takes private property to satisfy a tax debt and sells it to the highest bidder at public auction, the government is only entitled to keep as much as it is owed from the proceeds of the sale. Any surplus remaining after paying the taxes, penalties, interest, and fees belongs to the former owner, even where state law purports to give the money to the government. By allowing the city to purchase the property for an amount only equal to the debt, rather than selling the property at auction, the county denied the homeowners the remaining value of their home. This appears to be a clear example of depriving someone of the property they have and the value of their home without following the law or due process. Now, this case was first heard by the District Court for the Eastern District of Michigan. The district court dismissed the takings claim against the appellees, but failed to state a claim, misconstruing Raffaelli as holding that a plaintiff's only property interest surviving a tax foreclosure is not in the real property itself, but only in the surplus proceeds resulting from the tax foreclosure sale, if any. When property is taken, what value is it given? More importantly, who decides what that value is? Since the county did not sell the property at public auction, there was no opportunity for the collection of surplus proceeds. This either deprived the homeowners of their rightful property, the proceeds of the sale of real property, or deprived the taxpayers of the windfall from the sale of the foreclosure. The court dismissed the procedural due process claim against the county and its treasurer for failure to state a claim, holding that notice was constitutionally adequate because the payment plans themselves warned the homeowners that they would lose their property if they missed a payment. Were the homeowners notified that they would lose not only their property, but the equity they had in that property? Were they notified that the county would not auction off their property, thereby allowing them to retrieve the equity they had earned in it? The court dismissed the excessive fines claim brought against the county and the city, holding that the alleged actions here were not punitive and therefore there are no fines involved. I would direct the district court judge to the Law Dictionary definition of punitive. Relating to punishment, having the character of punishment or penalty, inflicting punishment or penalty. How can losing $308,000 to satisfy a $22,000 fine not be considered punitive? I am reviewing the appeal, not the district court's decision. From what I've seen, though, it was a pretty bad decision. The question is, will the appeals court give these homeowners redress for their grievances? I also wonder what the people of the city of Southfield and the county of Oakland think about this land grab. Do they think it is right for the county to sell property they have foreclosed on for a small fraction of what it's worth? Are the citizens of Southfield okay with their mayor and city manager running a scheme to get cheap property? And just what is being done with that property and who is benefiting from it financially? I think this is a case worth watching. What are the limits placed on governments when they foreclose on property? Do those in office have a fiduciary responsibility both to the homeowner and the taxpayers in how they dispose of the property? Are the accusations being made in this case something that could be going on around the country? This is just another reason why it is important that the American people not simply focus on Washington, D.C. and their state houses, but on their county and city governments as well. Listen, losing your home to a foreclosure is a terrible thing. It's painful. It's got to be awful. But imagine having salt rubbed into that wound. Imagine working years, if not decades, to build equity in a home, only to lose it all because you failed to pay some taxes and some county and city officials appear to be running a scheme. And imagine your home is taken to be sold to a private entity and it gets called for public use. These are abuses of the people. They're violations of the Constitution of the United States, the Constitution of Michigan, and the laws of Michigan. And these people are still looking for redress. So I'm waiting to see what the Sixth Circuit does with this. It should be interesting. The district court, I believe, failed these people simply because they wanted to come up with some legal mechanism to say, oh, this isn't a fine, it's just a taking your stuff. And while this case is worth watching, if you live in Oakland County, Michigan, especially in the city of Southfield, I hope you saw something. If you know somebody who lives there, please send them this video, this episode, this article, and let them see what their city employees and their county employees are doing in their name. Ask them, are they okay with city officials profiting at the expense of homeowners, of denying them the value they have in their home in order to satisfy a tax debt? And remember, it happened to someone else. That means it could just as easily happen to you. Now, if you enjoyed this episode, please share it. One of the biggest things you can do to help promote the Constitution study is share the material. Let other people find it. Let other people see it. I refer to myself sometimes as the Johnny Appleseed of the Constitution. Well, you can help me by spreading those seeds as far and wide as possible. Now, you can always find out more at constitutionstudy.com. I'd encourage you to join the newsletter. Once a month, I send out a newsletter with what's going on, but it's also where I put anything critical that happens. It doesn't happen very often, but when something important is going on, I might send you an email. You can even support the Constitution study, either, again, financially by buying some product or just donating to the cause, or, again, by spreading the word. I have lots of articles on lots of different subjects. There's an associated video, audio. You can find it there, and you can share it there. Now, if you want to get more involved in the Constitution, a couple things you might want to check out. ConstitutionScholars.com. This is where students of the Constitution gather to read and study and share their thoughts on the Constitution, to discuss not only national issues, but state issues as well, issues with their state constitutions. All up there. You can sign up absolutely free. But I'm holding an online Constitution study. Every 2 weeks, we get together on a Zoom call for 90 minutes, and we read the Constitution, we discuss it, we debate it, we answer questions, and you can join. Now, you can try it for free at the Constitution Scholars. Just look under classes, you'll find the Constitution study, and the first 3 lessons on the Bill of Rights, absolutely free. If you'd like to access the rest of it, well, you can purchase it right there on Constitution Scholars. We are still involved. We are actually still in Article 1, so you can get in on both the live events as well as the recorded events. Most of all, realize you're not alone. There are thousands, if not millions, of people in this country that are interested in the Constitution, interested in protecting rights and liberties, and you can join them. Let's help find each other. Let's help support each other. And let's restore the blessings of liberty to ourselves and to our posterity. And if that's something you're interested in, well, join me here next time for the Constitution study.
There's one thing you have to know wherever you make your stand. Came from